LSK, knowing the very well that this bill is there and seeks to bring forth the regulations and the sanity that you seek.
I'll tell you what happens to that bill.
How are you pushing that as well as LSK, and then you'll respond to that?
So for us, at least my council has come into office in the last 1 month, and we are taking a very kind of like systematic approach to deal with the space of mediation and also arbitration and other dispute resolution. We are engaging stakeholders in the ADR space. We've already engaged a number of them. We are engaging the judiciary. We are collecting data. We are doing fresh review to look at the philosophy and architecture of the bill so that it can be improved and made fit for purpose, and that it can take into account the gaps that have been there in the practice of mediation, because we are talking about court annexed mediation right now, including the need to re-emphasize the primacy of Article 50 of the Constitution and the fact that alternative dispute resolution does not mean dispute resolution contrary to the law. The law still remains a foundation of dispute resolution because it's a foundation of our legal rights and relationships. That's what we are trying to do. So we are basically saying that we'll have a solution. Kenyans need not worry, we'll have a solution. LSK is a very responsible interlocutor in the matter. We're also going to engage a few other professional bodies that have a lot of interest, for example, in arbitration, like the Architecture Association of Kenya, the architects, the engineers, etc. So we are going to come up with a solution. But we are saying that as we do so, we need to adopt the professional discipline that works in all the areas of provision of services of a high standard that impact on lives and welfare of Kenyans.
Fanya Mambo. What's up with the bill?
That's what I actually wanted to explain to you here. In 2022, this bill was doing very well. In fact, we thought it was going to pass. And he knows because he was a member of the Law Society of Kenya. And if he was not the president, he was a member. Hao ndio walikuwa kwanza kuipinga. And the reason they fought it that time, there was a provision in that bill that specifically said that before any matter is filed in court, it has to first go through ADR, and then if it fails ADR, it goes to court. The advocates did not want that particular clause. So it was thrown out specifically because of that clause. And then it's not had, there's no member of parliament who found it as a necessary bill to push it all the way. So the key issue, that was mainly, it was actually the Law Society of Kenya that they said, apana, you cannot have a law that allows us to, must go through mediation. We just want to go to court direct. Because that's where they thrive in keeping you there for 3.5 years.
Who thrives?
By the way, the advocates, I can tell you, again, the Chief Justice speaks about it. The target is 60 days within which we are supposed to resolve mediation disputes. She says the average of dispute resolution in mediation is 74 days. The average of dispute resolution in their court process is 3.5 years. If you're a Kenyan, where would you go to? Would you rather resolve your dispute in 3.5 years or within 74 days? And these are numbers. I love the fact that they come from the Chief Justice herself, because this information she's fed with from her own courts. And her courts are telling her mediation is a success story. Why do you have fewer registries? Open up more. As we speak, the judiciary is actually trying to roll up more registries to increase the number of mediators, to increase the number of cases that are being allocated to mediation, because there's no other place you come and speak of 91% success rates. There's no other place you come and speak of 64%. There's no other place you can come and speak of such figures. There's no other place you can speak of 74 days. 74 days for a court case, other than small claims, bado mko kwa mentions. Hata mjafika substantive hearing, mko kwa pre-trial, mko kwa mentions. You are still trying to decide how you are going to go about the case within 74 days. During that time, a mediator, done, dusted, they are on the second, third, fourth case. I think there's only one thing we need to agree on with the Law Society of Kenya. Mediation is here to stay. In fact, mediators are going to increase. If anything, we are going to fight to make sure that mediation grows. It is now upon the Law Society of Kenya to agree together with us that we need to take the ADR bill to Parliament. We need to sit together as stakeholders and say, we are all in this space. What do we put in this ADR bill? And what do we remove from this ADR bill? How do we make sure that mediation becomes a success? In terms of training, again, I tell him, there are 2 members of the Law Society of Kenya who sit at the Mediation Accreditation Committee. They have given a list of those institutions that have been allowed to train mediation in the country, they are about 35, 36 thereabout. Hawajafika hizo 50 nasikia. And also, in our training regulations, a class is not supposed to have more than 25 people. In fact, we've been in that space. I've been advertising my classes. I even have a class coming up next month. You'll struggle to get 25 people who can pay that amount of money to get the kind of training we are doing. So you'll probably have a class of 10, 15, 12, thereabout, on average. So when I hear somebody has 1,000 people and they're teaching them mediation,
even you are shocked.
It is too ambitious. It is too ambitious. Yeah. So all I would like to say is, let me tell you, President, we are together in this ship, and we have to find a way to make sure that it works.
Well, I think that's the word.
I need to answer. It's very important.
I hear what you're saying,
but it's very important.
We can regulate, Mr. President. We need to regulate the time here as well. Okay, so I can give you 10 seconds to do that.
10 seconds after all that he has said.
You've used 3.
You are going to leave your viewers with some issues that
go ahead, Mr. President.
So the first thing I want to say is that it is quite unfortunate to assume that Kenyans who go to the courts after they have made various attempts to resolve their disputes have gone to the courts casually. That they have gone to the courts because they don't realize it is a last option. That when they go to court because they're exercising their right under Article 50 of the Constitution to get access to the courts, they don't know what they are doing. So there are two underlying basic principles that underlie dispute resolution. The first is Article 50, that says everyone has a right of access to the courts. The courts cannot turn you away. And by the time people are going to the courts, they have tried everything else. It has not failed. They want the courts to be involved. And even if the courts take them to mediation, they want the courts to be involved in the process. Number 2 is that a fundamental principle in alternative dispute resolution, including mediation, is what is called party autonomy. It means the parties have a right to decide for themselves, and the parties are advised by lawyers. You can't force parties to go to a process that they don't want. You can't turn mediation into another court whereby the mediator forces you to make determination that you're not willing to make, or that you take away. You lose several of your rights that you had. So of course, as lawyers, we support alternative dispute resolution. What we are saying is that there are areas in court annexed mediation that are broken, and that we